In court.
Good morning, everybody. Thank you very much. Please be seated. And if you would call the case.
Good morning, Your Honors. The matter before the court today is the case entitled In Re Guillemette ZA Determination Appeal, case number 24 AP 141. Representing the appellants, Anne and Mark Guillemette, is David Cooper. Representing the appellee, Michael Casey, is Megan Grove. Seated at counsel table with Attorney Grove is Attorney Jeffrey Hand.
Okay, thanks very much. Come on up, counsel, please. If you would, and before you start, for the record, please introduce yourself and identify your client, and then proceed.
May it please the court. My name is David Cooper, Basie Gossam McPhee, and I represent Anne and Mark Guillemette in this case. We can surmise from the record that sometime prior to December 2022, Mr. Casey approached the town of Moncton zoning administrator and complained about certain activities that were occurring on my client's property. What we do know is that in December 2022, my clients provided a photograph to the zoning administrator in response to these complaints in an effort to put them to rest. The activities complained of were operations that had been going on for a long time and are the basis for my client's well-being.
So more than 15 years, Mr. Cooper. So it's exempt from the statute because of the length of time that has been utilized.
Exactly. The photograph, I believe, was dated 2004. And so the Guillemettes provided the administrator the photograph to demonstrate that the activities complained of had been going on for more than the statutory period for enforcement.
Go ahead.
I'm just going to cut to the chase, I guess. The appellee was given inaccurate information as to his appeal rights. He followed that inaccurate information, and it seems essentially that you're saying he has no redress because of that, appealing to the wrong court and without following the deadline dates that would have actually applied. What is his redress here?
His redress, if he believes he was damaged or harmed by misinformation, and his proper recourse, is against the party who gave it to him, in this case, the town. But his recourse is not to undo the bad thing that happened because he was given the wrong advice.
But if he sued,
I'm sorry, go ahead.
if he took action against the town, I don't know what his damages would be, but he certainly had no ability to contest what happened below by giving the wrong information. I don't think that's any monetary damage, but there should be some recourse, shouldn't there? I mean, I just don't really understand this argument that we gave him the wrong information, he followed it, and now he can't appeal this case.
Well, a few things. First of all, I guess make an analogy to, the statute of limitations. Okay. I mean, you miss it by a day, you have no recourse. Now, if someone gives you bad advice about what statute of limitations applies or when it expires, well, you may have a claim against the person who gave you bad advice, but you don't get to unring the bell. You don't get another chance to extend that statute of limitations.
Isn't there a distinction when the person or entity that gave him the incorrect advice is a party to the case?
Well, I don't know, but I know that my client wasn't the one who gave him the bad information. And let's be clear, yes, there was a reference to a 30-day appeal period, but surrounding that language was also instructions to refer to the rules and to call the environmental division for information specifically about deadlines. And here's a question. What would have happened if he had been represented by counsel? Could counsel have relied on the reference to 30 days?
But then the remedy would be potentially be a malpractice suit against the attorney if the attorney didn't follow the appropriate rule.
Exactly.
But isn't there so many saving clauses like Rule 60B or causes of action that are created with bad information. Who's got the duty here to provide the appropriate information?
I think everyone has a duty to do the minimum amount of due diligence to understand what their rights and responsibilities are when they enter the legal system. I mean,
But
Mr.
when the administrative officer, I mean, there's no dispute about what was said here. The administrative officer said the appeal period is 30 days. In writing, said that.
Well,
And that's wrong.
I dispute that. I believe that he used a pre-printed form that it contained that information, but I see that as.
So isn't that a statement when he signs it and provides it and it says on there, the appeal period is 30 days, you're saying that's not a statement?
It could be construed as such. I don't think we know all the facts. We don't know if Mr. Casey had actual knowledge of the 15-day appeal period. He was familiar with the ordinance. He had referenced that ordinance in his communications with the zoning administrator. He may have taken many appeals and known about the 15-day period. All we know is months later, he retained counsel and they made the argument that his untimely appeal was due to this language and stock language at the bottom of a form. Now, maybe that was true, maybe it wasn't.
From a
But I
government
think-
agency, though, Mr. Cooper, it came from a government officer, somebody who has, in theory, knowledge about these types of situations. And why wouldn't a self-represented litigant just rely on the information that's contained on an official document?
Again, I think you have to do the minimum amount of due diligence to check something like that. And what I don't understand is if we're going to create an exception to the finality doctrine as recognized and implemented by this court in the Jersey Street case, which set up that doctrine is almost sacrosanct.
What about that Langlois case that I think both of you cited in your briefs? What do you say about that one?
Sure. Well, that was an estoppel case. And so when you're dealing with estoppel, you're almost by definition balancing equities among the parties. That's not the case here. I mean, this is finality. This is jurisdiction. So as this court interpreted the finality doctrine, it's sort of like a statute of limitations. It doesn't matter how unfair it is. It doesn't matter, what the equities are. It is, did you miss the deadline or didn't you? If you did, then you're out of luck unless you can specify and point to a specific mechanism that is designed by the legislature to create an exception to that finality doctrine.
So would it be true, the statement you just made, would it be true if the administrative officer had deliberately given the wrong information?
I
I
think
don't
it
like
would.
you people. Here, the appeal period's 30 days. Good luck.
Yeah, I think that's a fair question. And I think the legislature needs to fix it. But what I'm saying, I'm reading your decision in Jersey Street. And I'm saying the courts say that unless there's a clear mechanism for avoiding a finality doctrine, a jurisdictional deadline. I mean, this is not.
Well, we issued a decision last month involving the Human Rights Commission. You know about that case?
I'm not familiar with that case, so apologies.
All right, I'll leave it out.
But I believe that, as this court stated in the Jersey case, if there's not express mechanism for avoiding the finality doctrine, you're kind of out of luck. And it does seem harsh. But what we don't know is what Mr. Casey's actual knowledge is. And again, I don't understand if we're going to create an exception to the finality doctrine for
Was
a situation like this.
8504 the remedy?
I'm sorry?
Isn't statute 8504 the remedy to ask the
Manifest injustice.
manifest injustice? Asking the environmental division to remedy this under manifest injustice. And the attorneys, when he did get attorneys finally, they made that argument to the environmental division.
Yeah, the problem with that is that chapter is 220. It is for consolidated appeals to the environmental division. So it consolidates appeals from state agencies, from district commissions, and from municipal panels. Okay. And one of the purposes is to standardize appeal deadlines. So what you see in 8504 is a standardized 30-day appeal period that applies across all of the appeals that go to the environmental division. That nothing in that section, in that statute or that chapter applies to an administrative officer decision. These are ministerial acts. That's why in the finality doctrine itself, 4472, it talks about acts of administrative officers, not decisions. Decisions are issued by municipal panels. Typically, you don't have a decision issued by a zoning administrator. This is a unique case. But typically, sorry?
Mr. Cooper, do you think that the environmental division sidesteps section 4472?
Yes, absolutely.
Can you expound on that for me, please?
Yes, I mean, the environmental division didn't even mention, I mean, when this court issued its Jersey Street case in April, I believe, at that point, our motions for summary judgment were pending before the environmental division. I read that case and I was like, we win. I mean, I'm not saying it's the right or wrong decision. I think it was right, but, you know, so I submitted the supplemental. I submitted it to the environmental court and Mr. Casey's counsel responded with their view of that case. The environmental division didn't even mention it. And, you know, and that's part of why I'm here. It's like, look, I read your case in Jersey Street and it made a lot of sense to me. And let's just say, I mean, we're talking about equities. The attorney in that case, I think, had a better claim to equity and fairness than the party here. In that case, I mean, I looked up his brief filed in that case. And he said, this is a quote from his brief, in a novel argument, which if accepted would come as a complete shock to the environmental court and the Vermont land use law practitioners, the town claims that environmental rule 5B1 and appellate rule 4B5 apply only to superior courts and not to municipal panels, such as the CBA. This argument flies in the face of decades of environmental court jurisprudence. I mean, that attorney thought that he had good basis for filing a motion for reconsideration to avoid going back and forth to the environmental division and back to the municipal panel. There were environmental court cases saying you could do this. And so to save his clients money and judicial efficiency, he filed a motion for reconsideration. Well, you know, municipal panels meet once a month, so they didn't even get to it until after the appeal period had passed. And they said, what, you're out, we don't have jurisdiction. He said, what? And he goes up to the environmental court and this court, you know, reversed and said, no, you're out of luck. And wow, you know, I was pretty surprised by the decision, but I think it was a right decision. I do. And I think that setting a bright rule is exactly the way to go. And again, if the legislature doesn't like it, if they think it's too harsh, it's their prerogative to amend the finality.
I realize your light's blinking, but I want to ask a question.
That's fine. I'll stay as long as you like.
Thank you. Is the issue of finality as important here, given that this is an enforcement issue?
I don't think so. And I thank you for making that question, because you know, the other side makes this argument. I don't understand it. And in fact, this court speaks directly to it again in Jersey Street is that everyone is entitled to rely on finality. It doesn't matter if you are an opponent to a project, whether you are the project, you know, the permit applicant, whether you've opposed project, whether you, I mean, in this case, I mean, you know, let's be real. My clients' livelihoods were put at stake, put at risk, and they still are. I mean, this is what they've been doing for a living for over 20 years. And Mr. Casey filed an action, or at least, you know, requested enforcement action, and all of that was put into jeopardy. And this had been going on for 6 months. They provided a photograph in December. They thought they'd put an end to the matter. They find out, you know, 9 months later that this is still going on. I mean, you know, talk about equities. So, you know, we talk about fairness, but I do believe finality applies across the board. Everyone who participates in land use sort of process is entitled to the benefits of finality. Even the town. I mean, if there's finality to this issue, and Mr. Casey or someone else comes to the town and says, you got to get after those Guillemettes, you got to get them, they can say, no, finality. There's nothing I can do. You're out of time. So everyone gets to benefit from that stark, bright line rule. And I think when you look a little bit closer about the equities, I know Mr. Casey makes a lot of them. Number one, don't think it's as clear cut as you think it is. I think number two, I think my clients have as much claim to fairness as he does. And number three, I'm not sure it matters based upon this court's decision in Jersey Street. It's a bright line rule. And again, if it's harsh, it's for the legislature to fix it, not this court. Is there any further questions? I'll take the rest of my time.
Okay, thank you. We'll hear from counsel for the appellee, please. Come on up. You've been here before?
No, this is my first time, Your Honor,
Oh, all right.
in front of this podium at least.
Welcome, and please, for the record, introduce yourself, identify your client, and then proceed.
Good morning, Mr. Chief Justice. May it please the court. My name is Megan Grove. I'm with SRH Law, and I represent appellee Michael Casey.
Thank you.
We're here today because the Moncton Zoning Administrator issued a decision to Mr. Casey with incorrect appeal instructions. Mr. Casey tried to navigate the appeals process unrepresented and filed an appeal in line with those instructions. The narrow issue before the court today is whether 10 VSA Section 8504B2, the statute that permits the Environmental Division to allow an appeal to proceed to prevent manifest injustice, applies in this case.
And so, Ms. Grove, can you explain to me as best you can why that provision in Title 10 applies to this provision of Title 24 and how manifest injustice applies here? I mean, whether or not it's manifestly unjust, but why the statute itself applies to the zoning administrator's decision?
Yes, Your Honor. So the plain language of the statute applies in this case, and so Section 8504B, it's part of Chapter 220 of Title 10 that governs several types of environmental appeals. And with respect to municipal zoning decisions, Chapter 220 governs all appeals arising under 24 BSA Chapter 117, the Planning and Zoning Chapter.
But doesn't it specifically reference municipal bodies, municipal panels in the body of this particular statute? Isn't it narrowed in that way?
So subdivision B1 does specifically refer to the appeal from the municipal panel to the environmental division. But subdivision B2, I would make two key points about the language here. And first is that it starts by saying that it applies notwithstanding subdivision 1, which plainly means that it is not, its terms are not limited by subdivision 1. And the second point is that the plain language of the phrase act or decision under 24 BSA Chapter 117, that encompasses decisions made by administrative officers who make decisions under Chapter 117. And that language stands in contrast to the language that is used in subdivision 1. There it says an act or decision made under that chapter by a board of adjustment, a planning commission, or a development review board. So if the legislator had wanted to limit the decisions under subdivision B2 to be limited to those by municipal panels, it would have used that same language, but it didn't. By using different language, the legislature clearly intended to cover a broader range of decisions. And under this court's precedents, we should presume that the legislature chose that language advisedly. And the appellant's arguments would read that distinction out of the statute.
I wonder if you might speak to the Jersey Street case that opposing counsel has relied on heavily here and give us your view of why that does not provide the answer.
Yes, Your Honor. The Jersey Street case doesn't control the outcome here. Both cases do involve an untimely appeal, but that case involved tolling and whether a request for reconsideration tolled the appeal period. And Section 8504B2 simply was not an issue in that case. And as this court's recent Human Rights Commission decision explains, when there is another statute that provides an express mechanism for the environmental division to hear an appeal or for that appeal to proceed.
Well, that case involved the development review, the DRB decision though, right?
Right, but
And I think we went out of our way to make sure that the point was made that the principle of finality was not to be understood to be diluted in any way by that decision.
Yes, Your Honor. And in this case, too, the principle of finality is not impeded by applying Section 8504B2 here, because that is an express statutory mechanism that the legislature has enacted to provide limited avenues for relief. Again, it only applies in narrow circumstances, and this case is the very rare circumstance that does present an issue of manifest injustice.
Ms. Grove, if we were to find that eight months reward does not apply to appeals from a municipal officer, are there other grounds that this court could uphold for the environmental court decision?
Your Honor, so we believe that the plain language of 8504B2 does apply, but if the court were to disagree with that, I think the Jersey Street case, in that case where the court held that Appellate Rule 4 did not apply, the court then went on to consider whether some other form of equitable tolling would apply. And for the reasons set forth in our brief, we think that the finality considerations weigh differently in this case if the court were to go down that avenue. But again, the court doesn't need to reach that question.
I was just going to say the trial court never addressed the equitable tolling issue. They based on just manifest injustice.
Yes, Your Honor, that's correct.
Is there a time period where it's too late to raise the issue of manifest injustice?
I'm not sure, Your Honor, but in this case, the appellee clearly appealed within the 29-day period that he was provided. There's no indication that had he known that it was actually a 15-day period that he would have appealed outside that period.
Well, it's true. I'm sorry to interrupt you, but it is true, as your opposing counsel pointed out, that notice included other language that I don't want to say admonished, but certainly advised the recipient to check. It gave a telephone number for the e-court, I think. It gave a URL address, if I can get that out. So it was not limited only to the 30 days that was obviously expressed in it as well.
Well, Your Honor, I would start by saying that the facts in this case really are not in dispute. And under this court's precedents, the determination that manifest injustice would exist is that would be reviewed for abuse of discretion. And there's simply no indication that the Environmental Division abused its discretion here. And I would additionally say that the Langlois case expressly held that residents are entitled to rely on information that is presented to them by a zoning administrator. And under that case, Mr. Casey was not required to sort of second guess the express information that he was provided, that he had a 30-day window to appeal to the Environmental Division.
So did Mr. Casey have a duty at all to do anything more than rely on the information that's by the officer?
Again, Your Honor, the facts that this constituted manifest injustice are not in dispute here. And under that Langlois case, he is entitled to rely on the information that he was provided by the officer. And as an unrepresented litigant, as many folks who go before locals try to get these local zoning decisions are, there was no need to question the information that he was expressly provided by the zoning administrator.
Again, I'm sorry to interrupt, but we've actually said in a number of different cases, haven't we, that deadlines are equally applicable to represented parties as well as pro se parties. We've said that.
Yes, Your Honor. And he did, I think we concede in this case that he did not appeal within 15 days, but the legislature has expressly enacted a statute that provides for the avenue for relief in this instance.
I'm trying to test the parameters of your position here. And in this case, you say, first, there's no dispute about facts. Second, you say this was and correctly so, say that this was written information that was provided. Where would we be if there wasn't an agreement on the facts and the information was not written? In other words, your client says, this is what I was told, and the administrative officer says, that's not what I said.
Your Honor, I think if that were the case, that would have been the Environmental Division's discretion. That's what the statute vests them to look at the facts and determine whether they present a manifest injustice. So the Environmental Division would have had the discretion to make that determination. And the environmental division's cases that we cite at page 7 to 8 of our brief show that the environmental division is, when it's presented with different facts and an argument for manifest injustice, is applying that discretion correctly. I would point to the Bicknell Trust case where the environmental division said that there was no manifest injustice and an untimely appeal could not proceed. So the next point that I want to make is that this reading of 8504B2 is consistent with the exclusive remedy provision in 24 VSA section 4472D. So these statutes both generally cover the process for appealing local land use decisions, so they should be construed together and in harmony. And by providing these limited circumstances under which an appeal can proceed, even where those technical requirements are not met, 8504B2 does not circumvent the appeals process set out in 4472. It doesn't provide an alternative pathway to appeal, and it does not provide a mechanism to collaterally attack a zoning decision. It simply says that recognizes that issues can arise in the appeal process, and it gave the environmental division discretion to determine that an appeal should proceed where there was a procedural defect, where the person was denied interested party status, or there was some other circumstance causing manifest injustice, and allows cases that do have these issues, these narrow issues, to go through the exclusive remedy process. And that's simply what Mr. Casey is seeking in this case, is the ability to go through and get that exclusive remedy, have his appeal heard on the merits by the Moncton Development Review Board. So the third point I'd like to make is that the environmental division properly exercised its discretion to determine that where a zoning administrator provides these incorrect instructions and the recipient relies to their detriment, it's manifestly unjust to dismiss an appeal for untimeliness. So I want to emphasize again that the appellants don't challenge the environmental division's determination that manifest injustice exists here, or that the environmental division has abused its discretion. And so if you agree with us that the statute applies in this case, we submit that you should affirm the environmental division's decision.
If we said the statute doesn't apply, is there any other way your client could have challenged this?
Your Honor, I think as I responded to Justice Waples earlier in the Jersey Street case where the court determined that Appellate Rule 4 did not apply, the court looked to whether some other implied equitable tolling might apply. And so following that case, which as Mr. Cooper indicated, came out after we had briefed us on summary judgment, that could provide an alternative pathway.
So, Ms. Grove, I think I may have misunderstood you, and maybe you can clarify it for me again. You referenced the language of 8504B2, the notwithstanding language.
Yes.
And an interested person would be broader defined under B1. I read that as creating standing for a person who was not a party. That's not the case here. Is that incorrect?
Your Honor, when the subdivision B2 says notwithstanding B1, or what happens in B1, I think that includes all the requirements that are listed in B1, and that a 30-day appeals period is listed there. And so there's really no support in the plain language of subdivision B2 that says that you can provide relief in all circumstances except for an untimely appeal.
Thank you.
So in conclusion, if the court has no further questions, in section 8504B2, the legislature provided 3 limited circumstances under which it has discretion, the environmental division has discretion to determine that a zoning appeal can proceed even if it doesn't meet the technical requirements. And it did so using language that plainly encompasses the decision at issue here. We respectfully request that the court affirm the environmental division's decision. Thank you.
Okay. Thank you very much. How much time does the appellant have, please?
Appellant has 35 seconds remaining.
Well, there you go.
8504 cannot apply. If you look at it,
Mr. Cooper, though, if it did apply, would you agree that the circumstances are manifestly unjust?
I would disagree, and I don't know why I said in my brief that I disagree that he's been manifestly unjust for the reason I expressed. I think the equities go either way. We have no findings. The environmental court had no factual findings before it, no evidence findings to figure out which way the equities should be based.
So you disagree with what Ms. Grove just had stated?
I certainly do. And my last point will be to have the.
You finish your thought.
Thank you, Chief Justice. She said that the environmental court would have discretion in the instance that I think Justice Eaton said about whether if it was verbally said, if someone received verbal instructions, don't worry about that that 15-day deadline. You have 30 days, and they come back to that. You've just overruled Jersey Street. There's no such thing as finality. Now, every time he said, she said, you're in an evidentiary hearing to decide whether or not people can rely on the finality of a permit. Thank you very much.
Thank you very much. Please call a conclusion of the hearing.
The next hearing for the court is